Hello, everyone. My name is Captain David Harvey. I'm the first Vice President for the DC Post, and we're excited to have you here joining us here today. Um, we have currently around, looks like just over 30 participants right now. We've had 100 register, so hopefully more will come in as we continue. All right, well, let's jump right into the presentation. It's my pleasure to welcome you here today to our July 1st Friday luncheon session featuring Doug Hibbsman and Dana Malari from Fox Rothschild, who will be sharing their presentation on the Buy American Act. The first Friday series is provided to you through SAME's commitment to offering the AEC community effective training, development, and networking programs. And SAME DC Post is helping to sustain the future of the profession with these monthly educational focus sessions to deliver topics relevant, topical and relevant content for our industry. So thanks for joining us here today. So let's move ahead to the agenda. First, like everyone to go ahead and turn off their video unless you're a presenter, and ask you to mute if you haven't already done so. Feel free to kind of ask the presenter questions so we can address them during the Q&A portion. You can do that in the chat. Also, you can feel free to break out your lunch as well, since it is lunchtime here on the East Coast. All right, so let's start here with a moment of silence to remember all of our active duty first responders and all who are in need of our care and thoughts throughout the world right now. All right, thank you. All right, please join us for the Pledge of Allegiance. I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all. All right, I'd like to take a moment to thank all our DC Post sponsors for your support. So AMT, Black & Veatch, Christopher Consultants, Consigli, Spinoli, Stantec, WSP, Jacobs, Woods Peacock, AB Facilities Service Solutions, and Archie Consulting. Truly appreciate your support. We could not put on these events without you, and we are grateful for your outstanding sponsorship. Your support helps us to meet our society goals, including providing excellent content for members, industry, and government engagement, building resilient communities, connecting with our future leaders through our Students and Young Members Program, and enriching the STEM pipeline and preparing our military and veterans for life after the service. If you are not already a DC Post sponsor or would like to support our post with annual scholarships, we would love to add your name to the list of future programs and events this year. Please visit our website for more information about sponsorship levels and how you can give back to your community through your DC Post sponsorship. All right, now it's time for our main program. Please note we'll be providing one professional development hour from the DC Post. Look for emails from the Eventbrite system later today with a copy of our program slides and your PDH certificate. And so here's the objectives here. I'm not going to read through this. Instead, I'm going to introduce you to our presenters, Doug and Dana. While I'm doing the introductions, participants can use the chat to introduce themselves as well, share contact information from where you're from, or feel free to use the chat throughout the presentation to ask questions. All right, so Doug is office managing partner with Fox Rothschild LLP, Washington, D.C. office, and a member of the Federal Government Contracts and Procurement, Construction, Litigation, Privacy, and Data Security, Mergers and Acquisitions, White Collar Compliance and Defense, Health and Law, and Architectural Engineering Design professional firm practice groups. He represents national, international clients in defense, healthcare, engineering, information technology, construction, manufacturing, and services industries on complex contract, compliance, and litigation issues. Doug routinely assists clients with understanding and complying with complex federal contract terms and regulatory frameworks, including the Buy American Act, the Trade Agreements Act, and related legislation. Dana is an associate with Fox Rothschild LLP in Washington, D.C. office, and she is a member of the government's contract and procurement practice. She represents the government contractors in a broad range of matters, including internal investigations, compliance with regulatory frameworks, contract interpretations and disputes, and bid protests for interventions before a variety of federal boards and agencies. She also assists clients with risk mitigation and compliance policies and training. Doug and Dana, thanks for joining us today, and I'll turn the program now over to you.
Thank you so much. Thank you very much. Thank you, Captain Harvey. And we will go ahead and get started. And we appreciate the opportunity to present to everybody. It looks like we have roughly 40 folks so far, which is pretty darn good for a Friday, a nice Friday in August. And I will have Dana bring up our slides and we'll go ahead and get started. There we go. As Captain Harvey said, my name's Doug Hibschman. My colleague with me is Dana Molinari, and we are government contracts attorneys by trade. We work at a firm called Fox Rothschild here in Washington, D.C., and we are going to talk to you for about the next 45 minutes or so about things that you might have wanted to know about the Buy American Act, the Trade Agreements Act, and the Infrastructure Investment Jobs Act, but really might not have felt like asking. So we're going to hit a number of different subjects today, and we're going to talk to you about for about 45 minutes about those three different pieces of legislation that I just referenced to you. Now, I'll be the first to tell you that this legislation, in our mind as government contracts attorney, is fairly complex and fairly confusing. So what we're going to give you in this 45 minutes is we're not going to make you experts on the Buy American Act, the Trade Agreements Act, or the IIJA, as we call it. But what we want to do is make you a little bit smarter after this presentation than you were when you came into it. And specifically, we want to be able to help you spot issues. So when you have that next federal contract, that next federal subcontract, and a Buy American Act issue comes up, or Trade Agreements Act issue comes up, you're going to be able to spot the issue and be able to hopefully say, that guy from Fox Rothschild told me this, so I've got to ask some more questions on it. So that's the goal for the presentation today. And we have about 25 slides in 45 minutes, so we're going to go through them fairly quickly. But please, by all means, ask questions in the chat during the presentation and after, and we're more than happy to answer them as we go. Next slide, please, Dana. So here's a brief outline of the presentation and again, essentially the three big picture regulatory frameworks that we're going to talk about today. And we're going to talk about these regulatory frameworks in order, essentially, that you would look at them in a federal contract. So the first thing you're going to look at in a federal contract that you get for construction materials primarily is what we're going to talk about today is, does the Buy American Act apply? And if it does apply, what is it? How is it going to apply to you specifically? And how do you comply with it? Now, the Buy American Act is a very, very broad rule, but there's lots and lots and lots of different exceptions to it. So the general rule may apply, but then there's lots of exceptions that swallow the rule. So first, we're going to determine if the Buy American Act applies. And then if it does apply, we're going to determine whether there's any exceptions to the Buy American Act that would apply to you. And then we're going to talk about what's called the Trade Agreements Act. And the Trade Agreements Act, the best way to think about it is a monster exception to the Buy American Act. So if the Trade Agreements Act applies, the Buy American Act by rule doesn't apply. So we're going to determine when the Trade Agreements Act applies over the Buy American Act. And then finally, we're going to talk about what's called the Infrastructure Investment and Jobs Act, or the IIJ. And we're going to use a lot of acronyms today: BAA, TAA, IIJA. And if you haven't heard of the IIJ before, that's essentially President Biden's 1.2 or 3 or 4 trillion dollar infrastructure package that was passed back in November of 2021. And just now we're starting to see federal money from the IIJA roll out with federal regulation. So it's very much an issue in flux. And Dana's going to talk about that towards the end of our presentation. And then finally, once we hit all three of these regulatory frameworks, we're going to talk about some best practices that contractors should apply in essentially all federal contracts to make sure they're complying with these frameworks. Next slide, please, Dana. So just a little bit about ourselves before we jump into the nitty-gritty of the presentation. Again, we work at a law firm called Fox Rothschild. A little bit of a background about Fox Rothschild is our firm was founded in Philadelphia back in 1907 with just a handful of lawyers. In the 120 years or so since, we've grown to roughly 980 attorneys in roughly 29 offices nationwide. So we're what you would call a general practice firm, which means we have lots and lots of different practice groups. So we do government contracts, we do construction law, we do labor and employment, we do intellectual property, mergers and acquisitions. If there's a legal need out there, we have lawyers within the firm that can essentially fill it. 980 lawyers sounds like a lot, but really what that means is that we're a mid-tier law firm, a mid-tier size law firm. Big law firms nowadays have about 3,000 lawyers. So we have about 1,000. So we're really kind of in the middle. Now, what Dana and my group does is we work in our Washington, D.C. office, and we have roughly 25 attorneys that focus exclusively on government contracts, government infrastructure projects, and we also do a fair share of commercial construction projects. And we represent prime contractors, subcontractors, A&E firms, general contractors on commercial construction projects, manufacturers, suppliers, and sometimes commercial owners, but not very often. And people ask, what do we do as a government contracts attorney? Well, if you think about the life cycle of a federal contract, you have the pre-contract phase where you're a contractor and you're thinking about bidding for work. So we have a lot of our clients come to us when an RFP is issued and they want us to help them through making sure that they can bid for the work, making sure that they can comply as a small business, setting up teaming arrangements, setting up joint ventures and things like that. And then once they win the contract, then you get into the contract administration phase. So we help our clients through that process to make sure they're doing the work timely, to make sure they're getting paid for the work. If they have to put in a claim against the government, that they can do all that stuff. And then finally, the contract closes out, you get to substantial completion. You may have some claims that are hanging over, or you may have some disputes with some of your subcontractors, your designers, and we can help through all of that. Now, one big picture service that we give our clients is we work on compliance matters, which is what we're talking about here today. As you all know, as government contractors, theoretically or supposedly 30 cents of every dollar that you spend on a government contract goes to some form of regulation or compliance requirement. So we help contractors to ensure that they're in compliance with that myriad of federal regulations out there, several of which are the Buy American Act and the Trade Agreements Act. And we also do all kinds of other stuff like affirmative action plans, equal opportunity hiring on federal contracts, False Claims Act compliance, you name it. If it's related to compliance, we do it on a federal contract. And we like to say that if you sell a service or a product to the federal government, whether you're a prime, a sub, a supplier, or whatever, we can help you with any of your legal issues. So that's what we do as a firm. And there's a map of where our primary locations are at in general. We're in all the major markets in the cities. We have a big presence in the Atlantic coast. And of course, like I said, Dana and I work in DC. Next slide, please, Dana. So I'm going to turn a couple slides over to Dana, and she's going to give you a 30,000-foot overview of the three regulatory frameworks we're going to focus on today.
Good afternoon, everybody. Thank you for joining us. Yes, as Doug said, I'm going to give you a high-level overview of the domestic preference statutes we'll be covering today. There are a handful, and they apply in different circumstances. So first and foremost, we have the Buy American Act, the BAA. It's been around for a very long time, since the 1930s, and you will find it on federal projects with federal agencies for construction materials and supplies. You have to provide these materials and supplies from American manufactured sources. Then we have the Trade Agreements Act, the TAA. And as Doug mentioned, you can think of this as a big exception to the Buy American Act. When a contract has a certain dollar value, the TAA kicks in and you are allowed to get materials from certain designated countries that the United States has trade agreements with. Then we are going to talk about the IIJA. As Doug mentioned, this was recently enacted and it is a moving target. We're going to give you our insight in what we think it may, how it may be interpreted in practice, because right now we're just working from guidance documents and there hasn't been an official codification or regulation to give us guidance yet. So we'll give you a bit of detail on that. And then finally, we have Buy America, as opposed to Buy American. It has a lot of the same domestic preference requirements, but it's really more of the Department of Transportation and other federal transportation agencies. And it applies to infrastructure jobs, and again, very narrow in its scope because it only applies to Department of Transportation projects. Okay, so why should you care about all of these domestic preference statutes? Well, it's the law. This has been codified in the US Code, in the FAR, and in the DFARs. It's also frequently a contract provision, and a major one, because breach of it comes with pretty steep consequences. If you do not comply with one of these Buy American Act or other domestic preference statutes, you can be in violation of your contract. This means you can be terminated for default. You can be required to replace all of those non-compliant goods with compliant goods at cost. You can have your contract term and price adjusted. And it's pretty steep monetary damages you can face. On the legal end, you can face some serious civil and criminal penalties. Under the False Claims Act, you can have monetary damages, civil penalties if you knowingly fail to comply with these domestic preference statutes. So we pulled a couple examples just to kind of let you know how that plays out in practice. So in 2016, Novum Structures, Wisconsin contractor, got in some serious trouble under the False Claims Act for providing steel that was not domestically sourced. In this case, they falsified documents. They certified that their steel was from the US when it wasn't, and they had a $3 million penalty, which included, I believe, a $500,000 criminal fine as well. So they got hit with criminal and civil penalties. And then we have Ambu Inc. So in 2019, Ambu provided to the VA and DLA medical supplies that were from Malaysia and China. In this case, they violated the TAA because one of the few countries that does not have a trade agreement with the US, China, and Malaysia, you cannot get goods from them no matter how high your contract value is. In this case, they also falsified documents, and I believe it was up to 80% of the goods they provided to the government were from China and Malaysia. They got a $3.3 million penalty and faced some serious criminal charges as well. And a lot of these False Claims Act matters are brought under what's called a key tom case, where a whistleblower, often an employee of the company, reports to DOJ this violation. And it happens all the time. You see them everywhere, like Agent Smith here. And the moral of the story here is you need to comply with these domestic preference statutes. You need to make sure that you are supervising your employees, that nobody is trying to cut corners and get a better deal by using things that are not covered under the BAA. And it can be as little as $1. If one little item you provide the government is in violation of this, you can see anywhere from $12,000 to $25,000 per violation. That means every time you certify a document saying, yep, every item in here is BAA compliant, every time that can be anywhere from $12,000 to $25,000. And that's on top of having to remedy that violation. So these are serious issues and things that can often get overlooked. So you need to make sure you understand it and are in compliance with it. And with that, I'm going to turn it back to Doug to give you a bit more background.
Okay, thanks, Dana. So we've been doing Buy American Act and Trade Agreements Act compliance for a number of years. I've been looking at the Buy American Act for probably about 15 years now. And here's a list of things that we've kind of cobbled together over the years that are big picture thoughts that we relay to clients on how to look at these frameworks. And first and foremost, it's very, very complicated. As we just mentioned, you have Buy American Act. I mean, just talking about the names of the frameworks, you have Buy American Act, you have Buy America Act. You now, under the IIJA, have Build America, Buy America.
That's
and
right.
people get confused just by the names of these regulations before you even get into the text of what they require. So getting beyond the names, it gets very, very convoluted. The regulations are very thick, dare I say disjointed. And again, some of these statutes are almost 100 years old now, and the government's kind of cobbled them together piecemeal over the years. So they are confusing and complicated. So that's issue number one. I would also tell you that the Buy American Act and the Trade Agreements Act, I classify those as essentially the least understood and frankly, the most violated compliance requirements that we have in federal government contracts. Now, what do I mean by that? Do I mean that our clients and government contractors are out there intentionally violating the Buy American Act and the Trade Agreements Act? No, that's not what I'm saying. But a lot of contractors and a lot of contracting officers do not have a full grasp of the BAA or the TAA, when they should apply, and when they do apply, how do you comply with them? And I'll give you, for instance, and Dana said it earlier about the case with Ambu. Um, if you provide a Chinese construction material, something that's manufactured in China, you name it, a wire nut, a bolt, a washer, an HVAC unit that's manufactured in China on a federal construction project, you are not in compliance with the Buy American Act and you're not in compliance with the Trade Agreements Act. Not only are you not in compliance, you're violating those statutes. So I would say on pretty much every federal construction contract you go to, you're probably going to find some violation of the BAA or the TAA based on the materials that are being provided. So we'll talk through that a little bit more, but that's our independent observation over the years. You're going to find out in bullet 3 here, there's a lot of general rules, but the general rules in some cases are almost absolutely swallowed up by the exceptions. Bullet 4, the targets change, and we're going to have new targets implemented in October of 2022, and these targets are only getting more restrictive. So right now, to comply with the Buy American Act, and we'll get into these domestic components ideas, but you've got to produce domestic construction materials that are 60% American-made components. In 2029, it's going to be 75% American-made components. So the standards are only going up. They're not getting easier, but they're only going up. The Buy American Act covers two big picture types of things. It covers construction materials and it covers supplies. Those are the two buckets that the Buy American Act and the Trade Agreements Act divide things into. We're really just going to focus on construction materials today. We're really not going to talk about supplies. And if you're providing a supply to the government, you're usually doing it under a purchase order. And if you're providing a construction material, you're doing it under a construction contract. So the one thing I will tell you is that you need to be aware of the fact that there's construction materials and supplies, and they're treated in some ways very similarly, but in other ways vastly differently. So I just want you to know you might be providing a construction material, and you may also be providing a supply. The Trade Agreements Act, in our mind, essentially disincentivizes producing things in America. Now, that may not be the consequence or the intended consequence of it, but when the Trade Agreements Act applies, it entitles contractors to buy things from roughly 140 different countries. So it's a great exception if that Trade Agreement Act applies to your contract. Iron and steel manufacturers have a ton of pull. The restrictions on construction materials are pretty rigorous, but the restrictions on iron and steel construction materials are almost unmeetable. And we'll talk about that here in a second. And then the final bullet that we find is not only do contractors at times struggle with applying the Buy American Act and the Trade Agreements Act, but we also find that the government struggles with it as well. And again, because these are very complex rules and regulations. And you will read an RFP from time to time that will reference the Buy American Act, but doesn't reference the Trade Agreements Act when it clearly should be included. So there's a lot of confusion, not just on the contractor side, but also on the government side as well. Next slide, please, Dana. Okay, Buy American Act. Next slide, please, Dana. So we're going to talk first about the Buy American Act. And like I said at the outline at the beginning, we're then going to go into the Trade Agreements Act. And then finally, we'll finish up with the IIJA. Just a little bit of a background about the Buy American Act. It is a Buy American Act of 1933. It was signed by Herbert Hoover. If you care anything about the history of the act, it was signed by Herbert Hoover on his last day in office in 1933. And it was specifically intended during the Great Depression to protect American manufacturers, to essentially require the federal government to use domestically sourced materials on federal projects. Now, oddly enough, the standards and the thresholds of the Buy American Act really haven't changed a whole lot since 1933. I mean, the standards and the requirements are very, very much the same as they were back then. What has grown a lot is the exceptions, and we'll talk about the general rules, and again, we'll talk about the exceptions as well. So if you want to know everything there is to know in print, essentially about the Buy American Act, you go to FAR Part 25. FAR Part 25 101 covers supplies. FAR Part 25 201 covers construction materials. So if you want to know where to read these rules and regulations, you go to the FAR. That's the best place to find it. So a lot of people ask me, well, I think I'm providing a supply to the government, but it looks like it's under construction contract, or vice versa. I've got a purchase order with the government and I'm really providing drywall and brick and things like that. So is it a supply or is it a construction material? How do I tell? Well, your contract is going to tell you that. So you read the contract, you look at the NAICS code of the contract, and if it's a construction contract, you can be 99% certain whatever you're providing under that construction contract is a construction material. If you have a supply contract or essentially a straight old purchase order with the federal government, you can be pretty certain or 99% certain that what you're providing is a supply. And depending on whether you're providing a construction material or a supply, you're going to follow different sets of rules. Again, we're really just focusing on construction materials today, but I just want you to be aware that at times, under different contracts, you may be being asked to provide a supply as opposed to a construction material. And if it's not clear, if you don't understand from the contract whether you're providing a supply or construction material, you should ask questions up front of the contracting officer. Because like I say, the rules are very, very similar in some respects for supplies and construction materials, but in other respects, especially with the exceptions, they're vastly different. All right, so finally, we're into the nitty gritty. What is the Buy American Act and what does it require? And here's the general rule at the half part of that slide there. It's the general rule of the Buy American Act. It requires on federal contracts that contractors use domestic construction materials. And these have to be used on all federal contracts over $10,000 in value, which is also referred to as the micro purchase threshold. And they've got to be used on federal construction contracts that are performed in the United States. If it's a foreign construction project for the federal government, the odds are that the Buy American Act is probably not going to apply to you. But if you hit those three bullets there, it's a federal contract over $10,000 performed in the United States, which I would guess is about 99.9% of all the federal construction contracts the government issues, you're going to have to comply with the Buy American Act. Now, the one thing I will tell you is a lot of people refer to the Buy American Act as a preference for using domestic materials as if it's kind of optional or you can use them if you want. I will be the first to tell you there's no preference at all. This is a hard requirement. You must use domestic construction materials if the Buy American Act applies. Now, there are a number of exceptions that might say, if the contracting officer approves them, that says you can use non-domestic construction materials, but it is a hard requirement unless you get an exception. Next slide, please, Dana. So we're going to talk about construction materials. The Buy American Act has its own definition of what a construction material is. So one of the very first things you've got to determine is, I'm providing materials on a construction project. What is a construction material? And if at the very top of this slide, I've cut and pasted the Buy American Act definition of what is a construction material. And I'll just read it because it's very important to understand this definition. It's an article, material, or supply brought to a construction site by a contractor or subcontractor for incorporation into the building or work. Now, what the heck does that mean? Incorporation into the building or work? Well, I will tell you the easiest way to think about this is if you bring a material to site and you leave it at the site or in the project, it's a construction material. For example, if you incorporate or install lights or structural steel or CMU or concrete additives or concrete fibers, conduit, wire nuts, IT hardware, anything that you take to site that leaves that you leave the site and it stays in the building or the project, it's a construction material. Now, if you take something to the project site and you come back with it after the job is over, such as equipment, trucks, hand tools, generators, you name it, it's just used to build the project, but you don't leave it in the project, then it's not a construction material. So that's one of the easiest ways to think about it. But I will tell you, be aware of the fact of this incorporate into the work, because we have had contractors over the years who have taken products to their project site, just delivered them to the laydown yard. They turned out to be non-compliant products. And let's just say it's pipe made in China, right? Not a compliant Buy American Act country. Pipe made in China that they've never installed in the work. And an inspector comes out and says, this Chinese pipe is a violation of the Buy American Act. So you don't even have to incorporate into the site to get gigged for violating the Buy American Act. It can just be delivered to the site with your intention of actually incorporating it. So not only do you have to be aware of what you incorporate into the building or the project to make sure it complies, but anything that you ship to that site, even before you incorporate it, you've got to be aware that it's got to be Buy American Act compliant. Now, that doesn't happen very often, but it has happened in the past. And you don't want to be that contractor that has a laydown yard full of non-compliant Buy American Act products, because you can get in trouble for violating the Buy American Act that way. So that's a general definition of a construction material. The Buy American Act requires contractors provide domestic construction materials. What the heck is that? Well, there's two buckets of domestic construction materials. Both of them, and if you take nothing away from this presentation, anything to be Buy American Act compliant must be manufactured in or a product of the United States. If that construction material is manufactured anywhere else in the world but the good old US of A, it's never going to comply with the Buy American Act, ever, unless, of course, the contracting officer agrees to an exception. But to meet the Buy American Act, anything you put into a project must be manufactured in the United States. So the two types of domestic construction materials are unmanufactured construction materials that are mined or produced in the United States. That's bucket number one. What would that encompass? Very few things. If you look at that picture up to the top right, you see a pile of sand there. That pile of sand is going to be an unmanufactured construction material. And if you're going to provide sand on a project to mix concrete, to mix mortar, to do whatever you're going to do with it, it's got to be mined or produced in the United States. If you're building the border wall down on the border of Mexico and the United States, and you're bringing sand from Mexico as opposed to getting it from the United States, you're not compliant with the Buy American Act. What else would be an unmanufactured construction material? It's really hard to think of these, but something like river rock that you would take out of a river that wouldn't be a manufactured product. Actually, water for concrete that you're mixing water with, it's an unmanufactured material. And oddly enough, I've not seen cases like this, but theoretically, when you read the Buy American Act, if you're mixing concrete with water and it gets incorporated into the project, which it will, it's got to be domestically sourced water. So, and again, that's a uber technical reading of the Buy American Act. But again, that's how granular you have to get with some of this. So that's bucket number one. Bucket number two of a domestic construction material is a manufactured construction material, again, made in the United States, if it meets one of the following three tests. And we'll go over these tests in a second, but it's got to meet what's called the cost of the components test, or it's got to be a commercially available off-the-shelf item, or if it's wholly or predominantly iron and steel, it's got to meet a special iron and steel cost of the components test. So if you look at that picture at the bottom right hand of the slide, you will see a bunch of manufactured construction materials. You see insulation, you see steel studs, you see CMU, you see dimensional lumber. Any of those materials, if they're going to be Buy American Act compliant, number one, they've got to be manufactured in the United States. And number two, they've got to meet one of these three tests that we just went over. Next slide, please, Dana. Okay, so let's go through these tests. And again, we're just focusing on the tests for manufactured construction materials. which is going to be 90% or 95 or even 98% of what you're going to use on a project. The first test you've got to meet is what's called the cost of the components test. And what that says is that 60% of the cost of the components of a specific construction material must be domestically sourced components or U.S. components. All right, that threshold is now 60% as of October of 2022. It's actually 55% now, but will be 60% in October of 2022. And by 2029, it's going to be 75%. So again, these standards are only going up, and it's only going to be harder to comply with the Buy American Act as you go. So how do you run this analysis? And let's just take an example. You're going to provide to a project a custom HVAC unit that's made by Carrier in Indiana, for example. How do you know if that HVAC unit made by Carrier is meeting the 60% cost of the components threshold? Who does the test? You've got to do it. You've got to run the test to make sure that everything you're putting into the project is Buy American Act compliant. So first and foremost, you've got to determine what is the end product that you're producing. Well, right now we know it's a custom HVAC unit made by Carrier. So that end product is that HVAC unit. Then you've got to go through and determine what are the components of that HVAC unit. And then you've got to determine which components are domestic, which components are foreign. And then you've got to run the math and determine if 60% of the components are domestic, it qualifies for the Buy American Act. If only 59% of the cost of the components are domestic, then you don't qualify. So does that mean you've got to run this analysis on every construction material that you produce on a project? I hope not. How you deal with this is you get a certificate from the supplier. And Carrier should be able to say with a great deal of certainty that that custom HVAC unit that we're providing to your project is Buy American Act qualified, and you're able to reasonably rely upon that certification. And remember, it's got to be manufactured in the United States. So if you don't want to run the math yourself in the components test, you've got to get a certificate. Next slide, please, Dana. So the next test is what's called the commercial off-the-shelf items test. What does that mean? It means if you go to Home Depot and you buy a washer, you buy drywall, you buy insulation, and you're providing something to the government that's a commercial product that's sold in substantial quantities in the commercial marketplace, and it's sold to the government or provided to the government without being modified from the format that you sell it, they sell it to the public in, then it's a COTS item. So essentially anything that's not a custom item, that's got to be custom manufactured, is generally considered a commercial off-the-shelf item, which means you don't have to determine the cost of the components that we just went through. It can have 0% domestic components and qualify as a COTS item as long as it's made in America. All right. So it's got to be made in America. It doesn't matter where the components come from if it's a commercial off-the-shelf item. Again, how do you know that? How do you know it's made in America? Without tracing down every product you're buying and putting in the project, you get a certificate from the manufacturer or the supplier. And finally, we'll talk about this cost of components test for items that are predominantly iron or steel. And any item that's 50% more iron or steel is deemed to be predominantly iron and steel. And if you're producing any construction material that's predominantly iron and steel, 95% of the cost of that item must be made up of American-made steel components. Another way to think about that is only 5% of the steel for that item can come from foreign sources. So the steel lobbies, the iron lobbies are very, very strong, and they're very protective of American-made steel. That's why we have this provision in there. It's a provision that was passed by President Trump a couple years ago, but it's a very, very high standard to meet, and essentially requires you on the Buy American Act to produce all domestic steel with very, very small foreign content. Again, how do you know that? How do you know it's going to qualify? You get a certificate from the manufacturer or the fabricator. And again, you can reasonably rely upon that certificate. Next slide, please, Dana. Okay, Buy American Act. So again, we just went over the general rules. You've got to produce domestically sourced construction materials for federal contracts. You've got to meet one of those three tests, which means the Buy American Act is really, really, really hard to comply with. It's really, really hard to satisfy. But like we talked about, there's a bunch of general exceptions. Now, these exceptions, you've got to go to the contracting officer in advance and get them before you submit or when you submit your proposal. And the contracting officer is supposed to weigh them with your proposal and put them in the contract. And you can get an exception for a specific construction material, not all construction materials across a project, but a specific one if it's impracticable or inconsistent to produce an American-made construction material. If, for example, we have a special agreement with Canada that it says we can use Canadian products, you can get an exception. If a construction material is simply not available in the United States in reasonable quantities, you can ask the contracting officer for an exception. If the cost of the American product is too high, 20% higher than a foreign item, you can ask for an exception from the contracting officer. In information technology items, essentially you're entitled to a blanket exception. We're really not going to talk about that because those are generally not construction materials, but IT items generally have a blanket waiver. So if you want an exception on a project, how do you get it? You ask in advance. You've got to do your homework and you've got to tell the government why a custom-made HVAC unit should come from the UK or Canada or Mexico as opposed to producing it from the United States. And you've got to show them that you're entitled to an exception under one of these four issues or exceptions we just went over. You can request it and you must request it in advance. If you request it after you already get the contract and you're ready to start doing the work or you've already done the work, the FAR allows you to do it, but it's very, very difficult to do it after the fact. And I will tell you, it's very rare that contracting officers will grant these up front. So if the Buy American Act applies, you almost always have to produce domestic materials. So those are the exceptions. And again, a lot of them will swallow the rule if the contracting officer agrees to implement them. At the very bottom of the slide, there are a number of contracts where the Buy American Act just simply doesn't apply. Like we talked about, any contracts under $10,000, which are very rare. Contracts outside the U.S. generally don't have to follow the Buy American Act. Service contracts, not construction contracts, don't follow Buy American Act. And then, of course, the granddaddy exception of all is the Trade Agreements Act, and it generally says the Buy American Act doesn't apply. Next slide, please, Dana. All right, so Buy American Act, we just went over it. Now we're going over the Trade Agreements Act. And like I said, the Trade Agreements Act is a granddaddy waiver that the federal government implements to make it easier for contractors to perform construction projects in the United States. Essentially, the Trade Agreements Act is a blanket waiver implemented by the President of the United States, which says that construction materials can come from essentially 140 different countries besides the United States and still qualify as construction materials you can use on a federal project. Now, these 140 other countries that you can get these items from are called designated countries. So you're going to have domestic construction products and you're going to have designated country construction products. And they are treated equally by the federal government on a construction project. So essentially, the Trade Agreements Act is technically a waiver of the Buy American Act, where it says the Buy American Act no longer applies, but you can still satisfy the Trade Agreements Act by complying with the Buy American Act. So it still does apply. So it's a little bit confusing, but the easiest way to think about it is the Trade Agreements Act is a big waiver of the Buy American Act. Next slide, please, Dana. So here is the list of the 140 some countries that if you get a designated country product from, you're going to be compliant with the Trade Agreements Act. Now, I will tell you, when you go through these countries, I'd say 1/3 of them, a lot of people have never heard of. So I can't say how many construction materials we get from these countries, but if a construction material comes from any of these listed countries, it's going to be compliant with the Trade Agreements Act. But I will note at the very top of the slide, what's more important is really not what countries are compliant with the Trade Agreements Act, but almost which countries are not compliant. And here's a list of big countries where I think we're going to get a lot of construction materials that simply will not comply with the Buy American Act or the Trade Agreements Act. And like I said earlier, any Chinese construction product that you use on a federal project is not compliant with the BAA or the TAA. Anything from India, Russia, Brazil, Turkey, and a bunch of other countries not listed here are not compliant with the BAA or TAA. So if you're bringing products in from those countries, you've got to be very, very careful, and you can't use them on a federal project. Next slide, please, Dana. So when does the Trade Agreements Act kick in? When is it triggered on a federal project? Well, there's a dollar threshold. And pretty much any project over $7 million in change in value, the Trade Agreements Act is going to comply. Now, it doesn't comply to all countries. If it's over $7 million in value, it doesn't apply to Mexico. But then there's another threshold of about $12 million in change, and that applies to pretty much any designated country product. So any federal construction project over roughly $12 million in value, the Trade Agreements Act is going to comply, and you can use products from any of those 140 countries to comply with the TAA. Now, sometimes what we find is contracts, RFPs simply do not incorporate the TAA's provisions that should be in there. And that's very common. And if you see that, you should ask for guidance up front before you bid for it to make sure the Trade Agreements Act is actually incorporated into the contract. When does a TAA not apply to a federal project? Oddly enough, it doesn't apply to any federal small business set-asides. I don't know why that is, but if you're doing a construction project as a small business set-aside, you must follow the Buy American Act, and the TAA simply does not apply. Very odd to me. Next slide, please, Dana. So 2 ways to satisfy the TAA. First, you can comply with the Buy American Act and do everything we just talked about through the Buy American Act. You can provide a domestic construction material, meet all the BAA rules, and you will comply with the Trade Agreements Act, which is hard to do, like we just talked about. Or, which is easy to do, you can provide a designated country construction material from one of those 140 countries we just talked about. Now, designated country construction material is anything that's a product of, grown in, or manufactured in one of those designated countries. Or it's anything that's actually substantially transformed in that country. In any of those 140 countries, if they buy all Chinese components and they substantially transform it in the UK, for example, that is a TAA compliant product. It doesn't have to be from UK components. It doesn't have to be from United States components. The UK can buy all the components to make a construction material from China, substantially transform it in the UK, and it complies. Next slide, please, Dana. So what's substantial transformation? And again, that's what's required to take components in the UK and substantially transform it into a TAA compliant construction material. It's got to, here's a definition of substantial transformation at the top. You've got to take a couple different articles and substantially transform it with a different name, character, or use. So essentially, you've got to manufacture it into something different than the components are. Not a high standard, but it's got to be transformed. It just cannot be assembled from a bunch of different components, but it's got to be transformed or manufactured into something different. Okay, next slide, please, Dana.
All right, and now we're going to talk a little bit about the Infrastructure Investment and Jobs Act, as I mentioned earlier, the IIJA. So a little bit of background for you. It was signed into law in November 15th, 2021, so this is not even a year old yet. It's authorized $1.2 trillion for transportation infrastructure jobs. This is great for contractors, but it's going to come with some strings attached, especially a slightly different domestic preference framework. Of that 1.2 trillion, I put a breakdown here of 550 billion of which is going to go to new projects and programs. Again, we just wanted to give you a highlight of what is going to. So we have roads, bridges, passenger, freight rail, transportation and safety. We have ports and waterways, airports, school buses, even electric vehicle related projects. So within this mega bill, we have a small portion that's called the Build America, Buy America Act. BABA, B-A-B-A, you'll hear us say BABA, Build America, Buy America, and sometimes I'll just call it the domestic preference of the IIJA. So what it aims to do is strengthen already pre-existing Made in America laws. And that includes Buy American Act, that includes any other domestic preference you may find even at the state and local levels, which tend to incorporate some of the Buy American Act standards. So its goal is to really bring these domestic preferences into state and local projects. And while it says it's trying to complement these other provisions, it's not quite clear yet how much it will complement and how much it might conflict with already existing frameworks. Again, we just wanted to show you a big overview of what the spending is going to. You can see a lot of it is for previously authorized transportation funding, but and we have a good chunk here going to the Army Corps of Engineers to distribute. But big picture, big project that will be taking place throughout the upcoming years. So what do we have to go on? What does it mean and how will it be applied? On April 18th, 2022, only a couple months ago, the OMB issued a guidance document that's trying to make some clarity here for agencies that will now have to implement these domestic preferences in upcoming solicitations and contract awards. So it directed all agencies by May 14th, 2022, to incorporate the following Buy America, IIJA, Buy America preferences into their awards. So agencies right now should be incorporating these domestic preferences into solicitations. We have three buckets here, which is a little bit different from the Buy American Act. The first bucket is all iron and steel. Iron and steel used on a project for infrastructure must be produced in the US. Number two, we have a manufactured products bucket. And here, any manufactured products used in an infrastructure project also need to be produced in the US. And we have a cost of components test here. It needs to be greater than 55% of the total cost, unless another minimum amount established under applicable law. This gives some flexibility for Buy American Act standards and cost of component tests, which are scheduled to increase over the upcoming years. This allows some flexibility for the Buy American Act provisions to be incorporated into IIJA projects. And the last bucket here is construction materials, a little bit differently defined than the Buy American Act, and we'll get into that in just a moment. But all construction materials also must be manufactured in the US, meaning all manufacturing processes have to occur in the US. And here we have, so section 70921 of the IIJA, and just the number of that section alone lets you know how deep into this act we are. So the final regulations must be put in place no later than 1 year from the enactment of the IIJA. So we have until November 15th, 2022 for the FAR Council, for other agencies to get together and actually codify this into some regulations. And although it's coming up soon, major projects might be starting sooner than that. So only a couple days ago, on July 29th, the Federal Highway Administration announced its first round of funding to states for this 5-year PROTECT project. And that means promoting resilient operations for transformative, efficient, and cost-saving transportation. This project really aims to revamp a lot of public transportation to be more resilient in the face of climate change. And it's allocated to all states. And right now we have 1.4 billion allocated just in the last part of this federal fiscal year. But it's going to be a 7.3 billion project over 5 years. So we're expecting to see some states and local agencies taking this money and drafting solicitations for this upcoming project. So this money's coming soon, and we need to have some clarity on how these domestic preferences are going to be put in place in practice. So who does this apply to? As I mentioned, this is going to be seen on the state and local level, not just on federal projects like the Buy American Act. It's going to apply to federal financial assistance, whether or not funded by the IIJA. So even though we're getting all this IIJA funding, it's going to impact any federal grant to a state or local entity that's being put to use for any infrastructure project. So that's a very, very broad scope. We're going to see a lot of this domestic preference stuff really getting baked into the state and local level where it may not have been before. This is going to apply to articles, materials, and supplies that are consumed in, incorporated into, or affixed in infrastructure projects. It's very similar to that Buy American Act language about construction materials being incorporated into that final project. It's not going to include tools, equipment, and supplies brought to the site and then removed after, not incorporated into that end product. It's going to apply only to the extent a domestic preference standard is not already in place for these buckets, for the iron and steel, for manufactured products, and for construction materials. So again, it's trying to make some flexibility to allow other domestic preference statutes to control, but it's a little too vague and broad to know when or where that will happen. You're going to have to really focus on contract language and see what is being flowed down. And again, to try not to conflict with international agreements, section 70914 just simply says this section shall be applied in a manner consistent with U.S. obligations under international agreements. It's not very clear here. Is this trying to signal that TAA might be an exception to this as well? That's something that remains to be seen and hopefully will be clarified in upcoming regulations. Okay, so some of the definitions. What are these three buckets that are covered under the IIJA? We have anything that's an article, material, or supply. And it should only be classified into one of the three buckets. So, if you have an item that consists of one or more of these things, for ease, I guess, of categorization, you're only supposed to put it into one of the buckets. So first we have iron and steel. So all of this, anything that's predominantly iron and steel, again, very much like the Buy American Act, must be produced in the US, which means all of the manufacturing processes from the melting to the coating on the finished product must occur in the US. It doesn't have the cost of components test or the 95% component like the iron and steel under the Buy American Act. It's a little bit more vague. It's just everything manufacturing to make the final product just needs to happen in the US. For construction materials, it's a little bit of a confusing definition here. So we have article, materials, or supplies other than iron and steel. And it could also be a manufactured product, cement and cementitious materials, aggregates such as stone, sand, and gravel, again, similar to the Buy American Act, and binding agents or additives consisting primarily of non-ferrous metals, plastic and polymer, glass, lumber, or drywall. So it's similar to the Buy American Act, but we highlighted here a manufactured product is a type of construction material, but a manufactured product is also its own bucket. So it gets a bit complicated when you have a definition for one item being the same as it's a separate definition. So manufactured product here in its own bucket is an item consisting of a combination of two or more construction materials, or a combination of one of the construction materials with an item that is not listed as a construction material. So it's a little bit confusing here and a little bit to unpack. It'll be interesting to see how it's played out in practice, because these unofficial definitions here are really just guidance. The OMB made it very clear in its April 2022 guidance document that this is not binding. This is just an initial guidance document to help agencies draft some of these new solicitation and award terms. An example the OMB used for this manufactured product versus construction material said a plastic frame sliding window is a manufactured product, but just the glass plate would be a construction material. A little bit confusing. It'll be interesting to see where agencies are going to draw the line and hopefully give us more clarity. Another interesting thing is there is no mention of a COTS exception. That we don't know if it will come up. It's not mentioned in the IIJA itself. The guidance document didn't address it. And if there is no exception there, it'll be interesting to see how will Buy American Act principles apply to these. Will there be the same exceptions and exemptions for contractors, or will it really be just no exceptions at all? And then will be interesting to see how it will be applied at the local level. We were talking about how this might be applied in practice, and Doug and I were thinking, will it be more or less restrictive than the BAA? So for construction materials, this Build America, Buy America preference may be less restrictive. Again, we don't have that explicit 95% of things being American sourced steel or iron. And also for construction materials, it may be less restrictive because, pardon me, the cost of components, for manufactured products, the cost of components right now is just 55%. If it remains 55% and doesn't track the BAA, it'll be less restrictive. And let's see here for waivers. We were looking at the waiver language. It's very similar to the BAA, but with some interesting adjustments. One of the more applicable cost waivers that people try to get is a little bit more restrictive here. The cost waiver is going to apply where the domestic preference requirement will increase the overall project, not just the item itself, by 25%. So that's an increase from an item by item increase in cost of 20%. Now it's the whole project by 25%. So it'll be very interesting to see, and hopefully they actually get these new regulations out on time by November, because we have questions.
All right. Well, thanks, Dana. I will not go through the best practices because I see we're at 1 o'clock and we were supposed to finish a little bit earlier, and we apologize for that, but we tried to pack a lot of issues into this 45 minutes, and we're happy to stick around and answer any questions that you might have. And please feel free to reach out to us by email, which is at the end of this slide, directly, and we're more than happy to answer any questions you might have by email as well. So if there are any questions, I'll turn it over to Bree, and happy to answer this.
Yeah, thanks, Doug and Dana, for a presentation. I'm like feeling like a little bit froze up over here. The agency has a 3.5 billion coming out of the IIJA, and we're with the Department of Health and Human Services. And fortunately, our lawyers have an initial ruling that says that the Buy America, Build America does not apply. We'll see if that holds up with any litigation.
Right.
But that's where we are. That's where we're coming in right now. But again, thank you for the presentation. And as Bree said, if you have questions, we will hang on here a little bit and go through those. So before we wrap up the program today, I'd like to share some of the upcoming events that we've got coming on here. The next session, First Friday session, will be on designing for security in an active shooter event. That's going to be on the first Friday of September, September 2nd. And then we also have, if you'd like to participate in the lunch sessions, you can feel free to email Bree, and we can, or have a presentation that you think would be interesting for the group. You can email Bree. That information is on the website. Also, I'd like to make people aware that the SAME golf tournament is coming up on October 5th out at Andrews Air Force Base. I'd like to see everyone out there, if they can come out and hit the ball around. Pretty wide fairways, no challenges there. You can land like planes on them, so it's it shouldn't be nothing like the Masters or anything like that. So easy club. And so, do you know that 80% of the members are made up of small business? Well, there's a small business conference that's coming in November, and the early bird discount for coming to that conference ends in about 12 days. So get your registration in now. And then I think we got the rest of the schedule for the year. We got a lot of things coming up here. There's a river running family day, like kayaking and a picnic on the Potomac River, September 11th. There's going to be the Andrews Air Base show, September 16th to the 19th, where there's going to be a STEM booths that are going to be there for K through 12 grade, promoting STEM activities associated with that. Again, the next Friday luncheon, VIP networking at the Capo Speakeasy. That is a great event. I went to the run earlier this year. And then there's going to be a project tour at Fairfax Water, the Occoquan River crossing on October 20th. And then it'll be a happy hour following that. I'll be organizing that myself. So again, that's it. Thanks for coming to our first Friday session, and look for your PDH certificates to be delivered from the Eventbrite later today. And the recording of this will be on our website later on. So I'll stop here, and maybe looks like we'll go over if people want to hear some of the questions that were asked. We can maybe scroll through those here quickly. Bree, do you have those handy?
Yes, Garrett Slate, you had a few questions. If you're still on, would you like to ask your questions?
Yeah, sure. I had two main ones, actually. The first one was, I guess we had a question where if we've got some sort of a concrete plant or cement plant on our construction site as the main contractor, and we bring in fly ash, which is a small product that's only made in China, and some other water aggregates and whatnot, we've kind of taken the mindset of those materials are brought to put into a plant, and what comes out of the plant is the construction material. And I'm curious your thoughts. Again, if we have obtained it from a facility down the road, we would be interpreting it as what was delivered. We happen to be making it on site. Wouldn't we interpret the same way because yeah. Does that make any sense?
It does. I would argue that the fly ash that you're bringing in to mix into your concrete, if I understand that correctly, is a component of the end product, which would be the concrete mixture. And at that point, you should theoretically do the cost of the components test. And as long as the cost of the fly ash is less than 40%, say, of the overall end product, you're complying with the Buy American Act. You've got the 60% threshold now. In 2029, it'll be 75%. But you would run the fly ash as a component of that final concrete mixture.
Yeah. And I usually say, as a pretty rare example, I look at everything that hits the ground. And that kind of leads into my other question. If we get something shipped to a job in 3 boxes, is each box evaluated independently, even though it's part of a single unit that we'll be having to put together once it's arriving?
Yeah, so you've got to evaluate really what is the end product going into the project, how's it being incorporated. And like take the HVAC unit example, you're putting in HVAC, it's attached to a bunch of ductwork, it might be attached to a chiller. The end product is going to be somewhat subjective depending on how you're providing it and how the government's asking for it. So I would say that if you're shipping things together to a site in 3 boxes and the end product is something easily definable as those 3 boxes merged into one end product, I think you can back that up and say the end product itself is made up of these 3 boxes of components, and the 3 boxes themselves are not separate in distinct end products. So I will tell you that determining the end product at times is very, very hard and very, very subjective. And you could have one interpretation of it and the government another, but as long as you have a reasonable interpretation of that end product, you can usually support it.
Yeah, my struggle with that had been in the definitions. They had said the only time you can evaluate things as a single unit was the emergency equipment.
Mm-hmm.
And so it seems like if they say that, they really mean that's the only case you can do that.
Yeah, I mean, I can see that point of view as well, right? But I mean, if that's really their position, then you could just send it in one box and assemble it off-site, then it would comply. So I think that they're really looking at it as a form over substance issue. And the key is just to be able to support your position rationally. And usually if you can do that, usually the government will not lean on you on those kind of issues.
Makes sense. Thank you.
You're welcome.
We had another question from Patrick Grandelli, if you're still on the line.
Hi, thank you. Sure, just a quick one. I mean, you mentioned block and brick. And I was just thinking there's not necessarily steel in those, especially I don't think of brick as having steel in them. So why did you list them there?
I would have listed those as a manufactured construction material. So it's got nothing to do with steel or the steel cost of the components test, but those would be a manufactured construction material that theoretically has got to meet one of those 3 tests, right?
Okay.
It's got to meet the cost of the components test, or it's got to be a COTS item manufactured in the United States. That makes sense?
Okay.
So actually, it's only got to meet one of the 2 tests because the 3rd test is for steel and iron.
Yeah. So, I mean, we can say a brick is a COTS item. That seems so silly.
Well, you can
Okay.
say a brick is a COTS item if you're providing it to the government in the same format that it's sold to the public in, and it's manufactured in the United States, right? So Chinese brick is never going to comply no matter what. If it's manufactured in the US, regardless of where the components come from, and it's a COTS item, it will comply. If it's a custom brick for some reason that wouldn't qualify as a COTS item, then you've got to run the cost of the components test, which probably gets pretty hard at that point.
Okay. Thanks.
You're welcome.
Nice slides.
I'm glad you liked them. Thank you.
Thanks.
We have another question from Brian Hinkle, if you're still on. So Brian asked, do all DoD MILCON project contracts greater than 7 million fall under TAA, even if the solicitation only references FAR 52.225.
So 225 is a supply contract and not a construction contract. So that's, and there's a lot of confusion between 225 and 229, 2211, 22511, I'm sorry. But the short answer is if it's a 225-5 contract, it's a supply contract, not a construction material contract. And there's a great deal of confusion over those FAR provisions.
All right, we have one other person that has their hand up. Sunil, do you want to ask your question?
Yes. What happens to the cost sharing? Like a federal has some part of 80% or whatnot to local agencies or things of that nature, like private, or because there are like a state agencies, Fed provides funds to, and they'll be just providing probably 80% or whatnot. So what happens to those projects? Does the 100% of the cost gets you had to take into consideration for all this, or just a part of that?
Yeah, so generally on those regional state projects, like in DC, we have a lot of metro projects and regional rail projects. Those projects, if the Buy American Act is going to comply, are going to be baked into the RFP for those projects and the contract documents. So you're going to know in advance when you're doing work on those projects, even if there's only 10% federal money involved in it, sometime that's going to require the Buy American Act to comply or to flow down. So the contract documents on regional projects, state projects, local projects are going to tell you or should tell you whether there's any Buy American Act compliant, Buy American Act requirements at all. So you should know that in advance. And if you're bidding for work and you don't know if the Buy American Act applies or not, you definitely want to ask the higher tier contractor whether you've got to comply or not. And they will, in their own interest, flow these provisions down to you to make sure that you're complying if they've got to comply.
Good, good. Thank you. Thank you.
You're welcome.
That was good. Thank you. Great slides.
Great.
Thank you.
Thank you.
All right, last call. Is there anyone else that has some questions for us? That looks like it's it.
All right. Well, thank you, Bree, and thank you, Captain Harvey, and thanks everybody who's still hanging on. We appreciate it. Like we said, if you have any questions when you get our slides, please feel free to reach out to us. We're happy to answer some questions for you.
All right. Thank you, everyone. Thanks.
Thank
Thanks,
you.
Bree.
Thank you.